NACDL is the association of the nation's criminal defense bar.
Hi, welcome. All right, so thanks very much for tuning in. We hope this is a fun and informative hour. So what I'm going to do, just really briefly, is kind of give you a background of the landscape of where we are and how we got here. And there are really kind of there are really three periods in time that matter. There are the good old days, as there always are. Before April 4th, 2011, schools generally were free to make their own rules about how to handle allegations of sexual assault on campus. And many of them had standards like clear and convincing evidence. They gave a bunch of procedural protections to male students who had been accused. There was a great variety in how schools approached these, how they handled these cases, and each school was allowed to sort of express its individual community preferences for how it wanted to handle these disputes sort of within their academic programs. On April 4th, 2011, the Department of Education issued a Dear Colleague letter. And this is one way the Department of Education lets schools know how it's looking at certain areas of the law. It doesn't go through APA rulemaking. My firm is actually bringing a lawsuit challenging the April 4th Dear Colleague letter because of the lack of compliance with the Administrative Procedures Act. But they issued this letter, and it really changed the layout on how these cases have to go. It required that the standard of proof be moved to preponderance of the evidence, put in place a number of additional protections for women who are bringing these cases. And I say women, but I should say, especially in Patricia's Brandeis case, it's not always women who are the complainants. It changed the way some of the rights complainants have when they bring these cases. And it lets schools know that they are on notice, that the Department of Education is watching how they handle these cases. And the enforcement mechanism they have, which I'll go to now, even though it's a couple bullet points away, is that almost every school in the country gets a ton of money from the federal government. And if OCR finds that they are not complying with what OCR believes the law to be, they can try to take that federal funding away, which for a school would really be close to a death knell. So OCR has got just tremendous leverage when it's talking to schools and telling them about its enforcement priorities. The Obama administration, 18 months ago, 2 years ago now?
About 2 years ago.
Yeah, about 2 years ago, really kind of spearheaded by the vice president, issued a big report, came out and brought this issue again and more forcefully into the headlines. I don't know that there was really a substantive change in law around that. They issued more guidance. There's some things at the margins, but it really kind of ratcheted up the attention, and as there's more attention, the climate on campuses can change. At some of the schools, I think it did change, and the way schools started handling these, I think, got a bit more aggressive. Pushing back on that, on the other side, is some litigation. Male students, or students who are accused of sexual assault on campus, have little recourse if the school's procedure kind of tramples their rights. They can go to the Office of Civil Rights of the Department of Education. They can bring a complaint. Of course, they're free to do that. Many people think that OCR would not be super interested in pursuing those complaints about due process violations in the context of a Title IX investigation or proceeding. And so many people who were accused of sexual assault on campus and felt that they were railroaded, felt their due process rights weren't consistent with what's required, sued. And what I think you started to see probably about a year and a half ago, and you're starting to see more and more now, is that courts are getting involved and they're supervising these processes more aggressively. And we'll talk about that a little bit more at the end. Let me move on to tell you just kind of the background of how these cases work. This is the standard model. There are always twists and turns. the basic format is that, it all starts with a complaint, or rather it all starts earlier with, two people interacting, but then that leads to a complaint. And that launches for the school an investigation into what happened. And the way the investigation works changes from school to school, but generally they collect evidence, they talk to witnesses, and then they make I think it used to be you had a chance of killing this at the investigation stage. I don't think that's terribly realistic anymore. I think most schools, for fear of liability, then move it to a hearing. And you go to a hearing that, depending on the school, looks more or more frequently substantially less like a very informal trial. Like if you imagine an arbitration run by somebody who's got a master's degree in French literature and they're kind of winging it as they go through the process, that's not far off of what you can expect from these hearings.
Those are the good hearings.
French literature is great. You get to somebody who studied Russian, it's a nightmare. So there's a hearing that looks, sort of ish like a trial or something that a lawyer would recognize. After the hearing process, there is generally an appellate process. The grounds for appeal are incredibly narrow in just about every school and set forth in the school's code of student conduct. And at some point in the process, it varies from school to school. Generally, as part of the hearing process, at the end of the hearing, the school will announce sanctions. I think we used to see suspension, a lengthy period of suspension as being more on the table for one of these cases. Now, absent extraordinary circumstances, expulsion seems to be the go-to for most schools. Is that your experience?
Yes, absolutely. Yeah. Or a suspension. I had one student who came to me after being suspended for 5 years.
Right.
That's an expulsion.
It is, if you... Yeah, it's an amazing place. So that's like the basic overview. We'll get a lot more into the details of that as we move along this afternoon, unless you're on the West Coast. Okay. Now there are, as you probably have noticed, because you're criminal defense lawyers who are really smart people, many of these allegations, sexual assault, whether on campus or not, is a crime. And so there can be a parallel proceeding. There can be a criminal investigation, a criminal prosecution. We will talk about this more, but many of these cases are the kinds of things that no prosecutor, even if you imagine in your local prosecutor's office, imagine crazy person, right? You know who they are. Even that person would not bring most of these cases because the witnesses are all drunk. The conduct is really sort of nebulous, and in some cases may just straight up not be criminal. We'll talk about this when we get to affirmative consent rules. Affirmative consent is not the rule for purposes of criminal liability, but for many schools, their view is if you don't expressly get affirmative consent to each and every sexual act, that is a sexual assault. Almost no prosecutor, even that person in your local prosecutor's office, would not bring that as a case. Schools will generally not delay a case because there's a parallel criminal investigation. You're not going to get that stay the same way you might if there's a parallel civil action. And most schools will, some schools will actually require and have as a separate disciplinary violation if your client doesn't go in and talk to them. Most schools will at least hold it against your client if they don't cooperate in the investigation, if they don't talk. And so where you are often, if you're not able to provide representation in the criminal case in that jurisdiction, is you need to hire someone who can. You need to have someone sort of looking at that and just making sure that you're not doing something that could mess up a criminal case if the criminal case is there and is viable. I mean, my firm does these cases all over the country. We're criminal defense lawyers by training and disposition. But if I'm going into Poughkeepsie, I will want to talk to a criminal defense lawyer in Poughkeepsie about exactly what the predilections of that prosecutor's office are, if it's the kind of case that's anywhere near in the ballpark of where someone could bring it as a criminal charge. So that's kind of. Did you have anything to add on the?
No.
Okay. Cool.
So I'm going to talk a little bit about if your client comes to you or your potential client and already has either an inkling that a charge or a complaint's going to be made, and I'm going to use the term him, even though, as Matt alluded, I actually have represented a couple of women who have been respondents in these types of matters, but the majority are men. But the first thing that, one of the unique qualities about representation in this area is there's a tremendous amount of information that's available to you right off the bat simply by going on the website of whatever college or university is involved. Obviously, you want to get your hands on the student handbook or the sexual misconduct code and policy if you're going to be representing anybody in these areas, and you really need to review them carefully. Every school has, you may start seeing some similar types of formats and definitions, but don't assume that it's one size fits all. You really need to be looking at the handbook, both to understand the procedures, the parties involved, as well as the definitions that may be applied or already have been applied to the conduct that's been complained of. The other thing that we routinely do in cases is look at the school newspapers, blogs, feed in the word Title IX, sexual misconduct, take back the night, and you'll find that you can really get a feel for what's going on a particular campus. The more you are out in the boonies, the less you're going to find that there's a lot of activism on campus. The East Coast, West Coast, or the more Ivy League schools, there's usually a tremendous amount of activism on the victim's right side on campus, and you need to know that before you go into any sort of proceedings or interviews, because it gives you a sense of what is it that your client's going to be facing. The other thing is that you can oftentimes find statements that have been made by the parties who are going to be making some of the decisions that may be helpful to you to start raising questions of bias. Is your client really going to get a fair shake here? So to the extent you have the time and the inclination, it's definitely worth doing that sort of initial search. The other is to ascertain, as Matt said, many of these cases it would be unlikely that there would be any prosecution, but that doesn't mean that there isn't already a complaint to the local authorities. There are some schools that have memoranda of understanding where they're automatically going to let the local authorities know that a complaint's been made, and oftentimes the local authorities are at least going to feel that they have to do some sort of investigation or attempted interview. Or you may have someone who, a woman who went into the Victims' Rights Center and then was taken by an advocate to the local police to make a statement, and you have to obviously take those very seriously. So that's something you need to determine from the beginning. The second piece, as Matt said, one of the problems with these types of cases is the school doesn't slow down for a criminal investigation, and the police or the local authorities are going to move at their own speed to determine whether they're going to go forward or not. So one of the things that the school's under pressure to basically get an investigation done within 60 days. That's under the guidelines, and many of them have incorporated that into their policies and procedures. I've had situations where I know there's a parallel proceeding going on. I think that ultimately the criminal piece isn't really going to go anywhere, but it's dangerous for my client to start speaking to anyone before that's been cleared up. So I will often request more time in those situations from the school, fully expecting that they're not going to agree to more time. But part of this, and this will be a theme that Matt and I will talk about today, part of this is also making a record at every stage of these proceedings so that ultimately, if you need leverage at the back end, if things haven't gone well, you've got the threat of litigation because they've made mistakes along the way. So I always say, ask for what you want, ask for what you need, even if you don't expect to get it, because you're going to be creating a record. The other piece you're going to have to determine right from the start is, even if there is the threat of criminal prosecution, are you still going to allow an interview or a limited interview? And I think Matt's going to address that a little bit more when he talks about preparing the clients for these processes. But obviously, these are all judgment calls. There's no one size fits all. You really have to understand what your particular circumstances are. There are also other ways, even if your client isn't going to speak, to obviously participate in the process simply by, first of all, a lot of what we do in these proceedings is we may be dealing with counsel for the school to try to get certain aspects of the proceedings. If we think things aren't going fairly, I may begin a dialogue with the lawyers for the school. At the same time, schools are sticklers for dealing just with students on these. Like, they don't want to hear from you on what's the meeting about next week, who's going to be there. They want to hear from the student. So one of the things you're going to find yourself doing is being a ghostwriter for every communication with the school. The student is going to be the one who has those direct communications, but you're the one who's going to be writing, let's find out who's going to be at that meeting. Let's find out if you're going to be expected to give a statement there. Anything you think you need to know, we usually do it on parallel lines with me going directly to the lawyers who may be involved and the student going to the Title IX coordinator or any other people involved. The other thing you can do, and the student can certainly do this, it doesn't have to be through lawyers, is say, I want to make sure you speak to so-and-so and so-and-so and so-and-so. You go talk to Joe Smith, he's going to be able to tell you he was there that night, and he's going to tell you that she was perfectly able to speak, she didn't drink that much, and so you're going to be putting some things into the record that way without your client necessarily speaking. One final and very brief point, the question here is, does it matter who's investigating? These things come up, or how the complaint arises. These issues come up in usually two ways. One is a campus security gets a call. Some of the larger universities have very, mini police forces, and they get a call that somebody's been raped, and they go and start investigating and taking names and asking questions just like any other police force would. The other way that these arise is that a complainant goes to the office where the Title IX coordinator is and makes a complaint. And what I have found in my own experience is when it starts with campus safety, oftentimes there's already a quasi-criminal element that has been injected into the situation, and I take everything seriously, but I take those at a higher level of, hey, there really could be a criminal matter here, than something that's just risen through the Title IX office. And by the way, it's 18 months after the event, or 6 months. Some of these are very stale, and there's nobody who's going to prosecute something like that. But
right. Okay. So getting to the big question, whether you should let your client be interviewed. Most schools, I think it's fair to say, want to talk to your client very, very early on. And so depending on when you're retained, you've got to make a quick call about whether there's a criminal case out there that you need to be worried about. And I think these really fall in a range. You have some cases where you can tell this is never going to go criminal. I had a case where, in broad brushstrokes, there was a consensual massage. A young man's giving a young woman a consensual massage. Everybody agrees the massage is agreed to. And then he starts to think that she would like more than just a massage, so he touches her butt for, by her testimony, 15 seconds. She says stop, he stops, and then it gets real awkward and he leaves. That gave rise to a charge, and he was suspended. Now, I have trouble imagining a prosecutor who would bring that case, just because that seems not a crime. I guess you could, so in that case, if that's the client you've got, or to take one fact from the Brandeis case, there was an allegation that one of the instances of sexual assault was that two people in a long-term committed relationship, one of them woke the other one up by kissing him. And you could see how, the recipient of the kiss, of course, did not say, yes, you may kiss me now. So if you've got an affirmative consent statute, or affirmative consent rule, and you're really applying that very strictly, you could see how that, maybe that violates it. But you're never going to see that prosecuted, right? If you're in that world, I think it makes sense to not so much worry about the criminal case. Then you get to this vast swath of cases where there's some chance of a criminal case. You could see it, but you got to kind of squint. And you're thinking there's, I don't know, like 1 in 1,000 chance of a criminal case. And if it's a criminal case, it looks pretty triable and it looks pretty winnable. But if your client doesn't go in and talk, he's probably going to get expelled. That is the kind of case, depending on what the odds you think are, and obviously everybody knows the numbers are just, you're guesstimating, you're fudging. I think we're in the circle here. We can recognize the limits of our ability to predict things. Where I think it really is a client call. You can say there's a possibility, and if it goes criminal, that's a nightmare, and it's a nightmare in these ways, but, really, there's a certainty of really bad things happening if you don't go and get interviewed. And I think that's a judgment call for you and for the client. Often when you're in that world, when you're looking at these cases, these aren't whodunits most of the time. I guess I had one case that was a whodunit where there was a woman who it may have been a number of different people at a costume party. It sounds like the fact of the interaction is pretty clear. And really, you've got the universe of evidence, you see the texts, you don't have the video footage going in or out of the dorm, but you kind of know what's there. You can get to a place, and I absolutely, as a criminal defense lawyer, recognize the danger of this, but you can get to a place where you're pretty sure that you understand the whole universe of facts and what can really hurt your client in there. And you can get some degree of confidence that he can go in and give a statement that's not going to haunt him later, that would be the exact same statement he would give if he were on trial in a criminal case. If you're in that world, I think, again, it's a judgment call. You're assessing probabilities. And it's a call for you, it's a call for the client. One option to look at is whether you can provide a statement in writing. Sometimes what we'll do is we'll provide a statement in writing and then sit down for an interview, and the client really just sort of sticks to the writing. We find that's a good way to kind of structure things and focus the investigator where we want. And often, because kids are crazy these days, the evidence, the universe of evidence, is in the texts, Facebook messages, Snapchats, and I mean it's amazing how many social media platforms I've learned about from doing this work. Or amazing that I'm old and didn't know about them already. So you can really find the universe. They're having conversations at the same time all of this is happening. I mean, and this is really probably the next point we'll get to in a second. But you can really know with it a better degree of certainty than you can in many criminal cases exactly what's going on, exactly what the narrative is, and you're not really filling in as many open questions as you would be in a normal criminal case.
Let me just ask you, Matt, because one of the things, and I agree with you on that, one of the things that I found is you oftentimes need your client to explain the text messages that occurred after the occurrence, because you may have somebody who's apologizing, oh, I'm really sorry you feel that way, and that's where there's a lot of incriminating evidence that if you don't have your client explain why he said what he said and what the circumstances were, then it's going to be very difficult to have a not responsible finding.
Yeah, or the apology texts are a unique problem, but the especially in an intoxication case, the text expressing concern because she was so drunk, those are really, those can be a nightmare. Texts are crazy. Which is probably a good lead into our next topic, which is the evidence that you need to collect and preserve. So the very first thing I look at is getting the universe of electronic information, getting the texts, getting Facebook messages, getting Facebook posts from the complaining witness, and also from your client who may be an idiot and say something that's really not good. Twitter, like the universe of how people communicate these days is vast and bewildering, but like really sit down with your client and try to find each and every one of those. You can, in some cases, there's DNA, although I find that's pretty rare. I mean, generally to see a rape kit in one of these is pretty rare. Most women who I'm seeing bring these charges don't get a rape kit done, just because, for a lot of reasons. Security cameras are an excellent thing to lock down right away. One thing we've started doing is getting, trying to get a sense of where the cameras are on campus that could have possibly recorded the flight path of our client to wherever things happened, especially in an intoxication case, because you want to be able to show, both parties were walking normally. They're holding hands. They're like cuddling as they walk. It can really go a long way towards showing demeanor rather than having a witness testify about it later. And finally, just in terms of establishing a timeline, most dorms have swipe cards these days, and if they don't have a swipe card, you've got to sign in at the front desk. Those can do a lot to show, the couple was up in the room for this long, for that long, to really help you sort of flesh out a timeline of what happened and when it happened. Do you have anything more on that?
I agree. And we had one case, I think, that really turned on seeing the camera as the couple signed into the dorm, and the woman was chatting, doing all of the signing in, held the door open for the guy. About an hour and a half later, he comes down with her. She's doing the same thing, opening the door, hugging, signing him out, clearly absolutely able to do all of these things, and we think that was really the key too, because it was a very, very close case that he was found not responsible.
And I will also say, so with your clients, with the text messages, don't stop with your client. If there was anybody around that night, try to get their text messages. We had this insane case that I wound up litigating in federal court here in D.C. Shortly after the April 4th Dear Colleague letter came out, where I really don't understand kids these days. But this couple had gone back to a dorm room where there were like 4 other roommates in this. I don't know how people live like that, but and all the other roommates are awake and studying because they're like engineering students, and the couple comes in and starts sort of hooking up on the bed with the lights on in front of everybody else. And the other roommates are texting each other saying, wow, this is really awkward. I don't know what we do with this. And they decided to go to bed. And so they're live texting the encounter between the couple while it's happening, which is first of all, bizarre, but second, kind of invaluable evidence. I mean, aside from having video of the actual encounter, it's an amazing contemporaneous recording that we wouldn't have had if we hadn't talked to the roommates. And fascinatingly, the roommates told the school's investigator that it existed, and the investigator said, I don't need to see those, which is a nice fact if you're suing somebody for doing a bad investigation. Yes?
So I think that's a great segue in terms of making the record where either you or the student has written to the school to say, hey, there's these text messages out there, or I want to submit these, or here's why they're important, or lock down this video. And if the school doesn't do it, I always look at these cases in 2 ways. One is, I hope we can win at the disciplinary level. I hope we can put together as good a case as possible, get our client ready to be a terrific witness, and at the end of the day we get a not responsible finding, and that's obviously the best result possible. The second result is, okay, I'm making a record here because the school has in some way denied my client rights through this process, and they're going to be vulnerable if he's found responsible, either because I'm going to have something on appeal that we're going to still be able to work through in the disciplinary process, or we've got leverage for a lawsuit. So, as I said earlier, all of the correspondence with the school, the Title IX coordinators, the investigators, whoever's handling the internal process, that's almost always going to be between the student and that Title IX coordinator or someone in that function at the college or university, because if you try to insert yourself as a lawyer, they're gonna push it out. They're not gonna accept it. So the second piece is, and I know Matt's firm sometimes has a different opinion on this, but I don't in every case get the general counsel involved right off the bat, like, hey, I think things are going wrong here, or you've got a situation where in fact the conduct that's being complained of actually isn't a code violation, or it's certainly not sexual misconduct. I only do it in situations where I really feel like I have something good to say. If it's a common, ordinary sort of proceeding where they're following their procedures, but I want to make sure they do, I'm probably going to do more ghostwriting through the student to make sure things go as they should. But I think one of the most important things in these proceedings, if you're handling them, and it's hard to do, it's hard to get the discipline, it's you have absolutely got to document everything you do. So if it's not in an email, or it's not in a letter, it's a telephone call you made to somebody, or you were having a conversation while you were outside the room with the investigator, or you're sitting in while your client's being interviewed, you absolutely need to make a very, very careful record because of two things. One is when the investigator's report comes out, or the summary of your client's interview, and it's missing very crucial pieces that you need to say, hey, that was said in that room and your notes are so bad, we can't trust any of them, but here, that needs to go in. Or he said not, and you don't have the word not in there. That's very helpful during the process to absolutely make sure that the record's correct. The second piece is if you go to litigate against the school, guess what? They're not turning their records over to you after this process is done, and many schools have very limited look-sees at the record as you're getting ready to go into a hearing, and then everybody collects everything afterwards. The portals are shut down, and so it's absolutely crucial that you make a very, very detailed record as you go along. It adds credibility to any appeal you would bring, and it also adds credibility to any threat of litigation.
Yeah, I mean, I will say, so on the engaging with general counsel, we in almost every case, as soon as we come in, we send a litigation hold letter to the school to put them on notice that we may be suing them and ask them to preserve all their documents. Just because we've had a couple of cases where they've destroyed documents in the middle of a case that we think would be very helpful. And as a part of that, we'll normally reach out to general counsel's office just to try to start to open a dialogue. Because sometimes you can work stuff out between lawyers, and if you've got a Title IX administrator who's just off the reservation, you can talk to general counsel to see about getting them back on the reservation. It used to be that was kind of shocking, and that they'd get the letter and they'd think, oh well, we got to call and talk and deal with this. Now it seems sort of de rigueur, like they're becoming frequent enough that general counsel's offices are seeing these, and depending on who you've got, they'll talk to you and you can get more or less information. But you can often get useful information about what's going on campus. They'll complain about, we got 18 of these cases going now on 7 different satellite campuses. It's a headache, which is good to know. I don't know what decision you make based on it, but it's good to know.
Well, and they'll always tell you, I have nothing to do with this process. That's being handled, and you know that you hopefully have said some things that are going to get backdoored over to the process. So these cases are all about any way you can get a good result, go for it, and because you never know who's talking to whom. And one thing, let me just go back, well, it's not really going back, but one thing you should always consider when you get into a case like this, especially when you have two completely blottoed people, the accuser and the respondent. And the accuser's the one who's made the complaint. One of the things you should think about is making a counter complaint, or at least a complaint, or in the context of the investigation, bringing up that whatever she's complaining about, she did the exact same thing to me, or we were both, neither of us has any memory of what happened, and therefore why are you assuming that I'm the aggressor? You should always be considering that sort of counter complaint, and frankly, under OCR's guidance, the school really is they're obligated to investigate any complaint, so it's important to possibly inject that if it makes sense. The second piece with that is that the students involved, I had one case where the two students neither of them had a memory of what happened, and the investigators at the end of the process concluded it would be a Title IX violation. They put this in their report to find that the male student had been the aggressor, basically. And the school, in their infinite wisdom, decided to go forward with a hearing and found our client responsible. But that piece in the investigator's report was very helpful for leverage in terms of settling the case pre-litigation. So I think that's something to always consider, but you also have to look at the retaliation provisions in a handbook to make sure that you do it in such a way that your client can't be accused of retaliating just because a complaint was made against him.
Do you actually make the formal allegation?
I have done that in a couple of situations, and in others it's usually bringing it up in the context of the investigative interviews.
Yeah.
That if you're going to find me responsible for that, I need you to know that this happened on this occasion, and this occasion, and I think that's helped at times level the playing field.
Right. Right. I mean, we've done it where the intoxication cases are the hard ones, right? Where both of them are drunk, and if you're not able to consent, it's hard to see who's sexually assaulting who.
Right.
I don't know that we've actually made the formal complaint as much as made sure it's clear and a part of the record, because you want to tee up a selective prosecution claim if you wind up suing later or threatening to sue later under Title IX. But I've always been terrified of the retaliation allegation.
Yeah, I think you have to do it very, very carefully.
Sorry.
No, that's fine. That's fine. And then just very briefly, just like you would in any criminal matter, you should always be performing an investigation of any aspect of a case. And we've talked about using websites, Google, all of that you normally would. The one challenge at times that can occur in these cases is there may be a no contact order in place. Could be bilateral, could be unilateral between the students, or your client may be barred from going to the fraternity where this supposedly happened. He lives off campus, but he's a member of the fraternity. And oftentimes that could make it more difficult even for him to go talk to somebody and say, hey, were you there that night? Can I hear what you saw? And that can make it more difficult to investigate. But if the school is obstructing the respondents, again, this is making a record, making things, if the school's obstructing the respondent's ability to investigate what really happened, to find witnesses, then you make a record of it, push back, get in touch with the general counsel for the school, because otherwise your client is obviously going to be hampered in being able to defend himself.
Right. Expert witnesses. So, this is these hearings are, they're really like slop counts hearings. There aren't, strictly speaking, rules of evidence. We wind up, there are a couple of different categories of cases that we'll talk about in a little bit. One of the cases that you see frequently are intoxication cases, where someone will come in and say, I was incredibly drunk and I wasn't able to consent, and that's how I know this was a sexual assault. And what we've seen schools do, which is, if you think about Daubert or Fry, is insane, is they will estimate the complaining witness's weight, which is delicate in its own way, and then they'll take the range of drinks that she reports she consumed over the course of the night, and they'll feed that into an online blood alcohol calculator. And they'll come out with a blood alcohol level, which in some cases can be shockingly low. And they'll find that the standard for incapacitation is the same as like unable to drive legally, which, if you've got a DUI practice, you must be laughing right now. And the evidence against your client will really be just like this online blood alcohol content calculator. So if you're in that case, one thing that's worth thinking about or talking to someone about is an expert on what does this level of intoxication mean in terms of cognitive functioning. Many schools, when they talk about intoxication levels, they don't really define what incapacitation means. So I think that's on you, but talking to an expert about coming in and saying, clearly, if somebody's had this much to drink, this is how they function is an option that's possible and out there. Of course, that gets data in, data out, right? So garbage in, garbage out. Sorry. So the if you don't have an accurate-ish account of how much alcohol was consumed, it's a lot harder to do that. One thing we've done with mixed success is get somebody to do a polygraph. I realize there's a lot of dissent in these. I like the guy we use for polygraphs and find him pretty reliable. We also find that often our clients are so freaked out, even when we believe strongly based on other contemporaneous evidence like texts or Facebook messages, there wasn't an assault here. They just can't take a polygraph because their blood pressure goes up. There's so much anxiety around the charge. Generally, they're not good polygraph candidates. But when you can get it, I think they can be really effective. And one thing to watch out for, I've been in a couple of hearings where the school, they hire someone to do an investigation, and some schools, the investigator concludes at the end, so we find that there was likelihood there was a sexual assault here. I've been in hearings where the school has called that person to testify, and it's like a former sex crimes prosecutor who I'm sure sees lots of cases of not sexual assault. And that witness will say, I listened to everyone and I evaluated their credibility just based on their demeanor, and I can tell you who's lying and who's not. So really, hearing board, just kind of shut down and listen to me. I'll just tell you what the answer is. Now, obviously, that's insane, right? And that just shouldn't happen. But schools, if your master's degree is in French literature, you don't understand why that's not useful and why that's grossly unfair to have someone who's been hired by one side come in and just testify about the ultimate question, which is why, to the extent that you can see that coming, one strategy is, our favorite strategy is to call general counsel and just, jump up and down. Another strategy is to call another expert on the other side who can come in and say, here's actually how you do this investigation, and this is why you should be a little bit skeptical of that result. You've done this a couple of times?
Yeah, we've brought in some of the hearing, it's more been toxicologists. We have had them come in and testify after hearing what the accuser says about the level of drinking, and it's also already in the record. And I think that's been very helpful. And then we've sometimes submitted as part of the packet like a SANE nurse, an evaluation of the rape kit, toxicology analysis, those sorts of things, and I think we've gotten good results in those cases. I'm sure that those experts have helped sort of level the playing field.
Right.
One of the for any of you who have already done a number of these cases, you may have seen different models that are being used at different schools, but we just wanted to give you a sense of the types of proceedings that are out there. The single investigator model has all kinds of different connotations, but it can range from, and frankly, the Obama administration prefers this single investigator model in some of their materials. And I'll give you an example. Cornell's an example of a school that has, at least as of a year ago, a single investigator model was complaints made, investigator who's an internal person to the school. They're part of the office of the Title IX coordinator office, investigates, interviews all the witnesses, interviews the accuser, interviews the respondent, and drafts a preliminary report with findings of fact as well as credibility findings and ultimate findings on whether somebody's responsible or not, makes recommendations on sanctions. And that preliminary report, you can object to it, but ultimately it gets finalized. It gets handed off to a panel who never even sees your client, never even sees the accuser either, and just takes this written record and in most cases is going to rubber stamp what they get, because how would you even know to do anything any different? Obviously there's a lot of danger in that kind of model when you can't even hear what it is that somebody's saying you did. You certainly get it in writing, but you're not sitting there hearing it, being able to possibly pick it apart. It's very, very difficult to defend yourself in a single investigator situation. And I think in those those situations, it's incumbent, if you've got issues related to intoxication or rape kits, it's like get experts in those cases, because you're going to have very little ability. If the investigator finds your client not credible, there's no other way you're going to get a not responsible finding. A lot of schools do a hybrid between a single investigator, someone who actually might do all the findings, including credibility findings, prepare a report, but then there's going to be a hearing after that report is prepared. That report and the packet of evidence is handed off to the panel. It's usually now faculty members or staff. Students are less and less on these panels, which I think is a good thing. And they may have a hearing that only involves bringing in the accuser and the respondent. They're oftentimes kept in separate rooms, so you're maybe viewing somebody's testimony through a closed circuit TV, but at least your client gets to be live in front of the ultimate decision maker. And I think that's obviously better than just having the first single investigator model I talked about. There's also hybrids where you'll have an investigator who acts like many investigators do. They're fact gatherers. They put together a packet, and then they hand it off to either a panel who will hear testimony not just from the accuser and the respondent, but witnesses as well. And there are also instances where a school will bring in an outside adjudicator instead of a panel, maybe a former judge. And Matt and I were talking about this before we came here today. We personally like it when this is a more professionalized process, and some outside adjudicators can be very good at cutting through the evidence and weighing it a lot better than faculty and staff who are brought on to decide these cases. The other piece of this is the right to confront witnesses. Obviously the single investigator model, I just described why it's rife with problems, because you're obviously not going to get to cross-examine the accuser or any of the witnesses. But even in a panel model, the guidelines from OCR hold that the accuser, first of all, your student's going to have to be the one who represents himself in the proceeding. You're not going to be able to, in most proceedings, there are some where counsel can actually act as counsel, but the vast majority, it's a student who's going in there and defending himself. There's no cross-examination between the accuser and the respondent. It's done usually through a panel. The chair of the panel is going to be the one who decides what questions get asked on cross-examination to any witnesses. And so it's a very, very limited process. I will say, I think what we generally do when we go in as advisors in those situations, we have a set of questions based on the record that, as we know it, that we think should be asked depending on what comes out of anybody's mouth at that moment in time. I tend to do different questions on different pages so I can help the student mix and match. If you hand up a list of pre-prepared questions, the problem is you're going to have some chair of a committee who's just going to start reading these questions off, and some of them may not be good questions to ask anymore because of concessions that have been made. So I usually have a bunch of different questions on different pieces of paper, and I'm also ready to help the student writing out questions in the moment to be able to hand up. And again, and I know I sound like a broken record, but keep a record of what gets handed up, what doesn't get asked that you think should have been asked, because at the end of the day, that has been the key to wins in some of the litigation that has arisen out of these Title IX proceedings, where courts have determined that the right to cross-examination was hampered because questions that should have been asked weren't asked.
Right. Okay. So the sexual assault cases are all about consent, and let me go through this quickly because I think we're a little pressed for time. There are really four kinds of cases. First, there are affirmative consent cases. Most schools, and in California, all schools have a requirement that in order to proceed with a sexual act with another person, you have to receive affirmative consent. Which normally doesn't mean verbal consent. It just means clear and unambiguous consent. So actions count. However, exactly how that gets parsed is complicated and fact-based. You would think there would be a reasonable person standard, but you would think a lot of things about how the world should be. So you do find yourself, when you're preparing a client, I mean, the problem is the way these things get expressed in our interactions with one another is through lots of different little movements that you don't normally pay attention to as they're happening. It seems rare to have a client where there's an express conversation about moving to the next stage. And so you wind up trying to sit with your client and have them describe little micro movements that they took as consent at the time, which is tricky and awkward but necessary to get them to describe. This is how the person sort of like moved her hand or shifted her weight or whatever. So the next, those present real unique challenges as you sort through them. That said, I think those are also where you get kind of absurd results, like the partner kissing the other partner awake. And if you find yourself in front of a judge later, I think those are also the kinds of cases where the judiciary just recoils at thinking that that's actually the kind of thing that should get someone expelled with a mark on their transcript for life. Okay, incapacitation is a separate issue. It seems to me that everyone in college drinks to blackout every night, although my experience is probably, I hope, not typical from having read these cases, not from my own collegiate days. So incapacitation cases get hard because what you've got to do is separate drunk from incapacitated. Some schools have great standards, inability to understand the who, what, where, when, why, or how. That makes sense. There is a school in New Orleans that has a very express language. Drunk is not the standard, incapacitated is the standard, and that means something much, much more than drunk. But if it's in New Orleans, of course it would say that. Other schools, most schools, I think, just don't define it. They say if you're incapacitated, it means you can't consent, and incapacitated means you're just not able to consent, which is, super helpful. So what you wind up having to do is focus on things like, slurring speech, throwing up, passing out, and really trying to navigate as much as you can about just how many of these excessive indicators of real excessive drinking are present in the testimony about the complaining witness's behavior. If you've got throwing up, I think that's a hard case. Relationship cases, these come up often. I think one fact pattern I feel like we see a lot are people who, complaining witnesses who bring a charge, couple of days after the final breakup. That is really awkward. And what you want to do in those cases is really kind of establish the history of the whole relationship. And finally, BDSM cases, there aren't a ton of these, but there are some of these, and they present unique challenges that I am sure you can imagine. All right, let me move on, to preparing your client for interviews or hearings. Here is just a horrible thing that happens in these cases. There is this emotional dynamic in the room, right? So the complaining witness comes in and is crying and is incredibly upset and is pointing the finger at your guy, either in the next room on video or sitting in the chair across the room. And everyone seeing someone in that situation of emotional distress feels for her and wants to do something for her. And then your client comes in who is angry, who is falsely accused, who can't believe this is happening. And it is an outrage that he is even sitting here. It is an outrage that his parents have to spend all this money on a lawyer. And he is just sick of it. And what you have is a woman who is in emotional distress who looks like she was assaulted. And you've got an angry man who looks kind of like how you'd imagine a rapist would look. And that is death for your case. I think a lot of these panel members are not lawyers. They're not sophisticated about thinking through evidence and facts and rules, but they're super sophisticated about reading people. And they do that all the time. And if that's what they see, man, you are in a world of pain. So we spend a lot of time just working on demeanor. And what we started doing with our clients, and we started doing this in our non-campus cases too, is if we're working on a witness statement or with a client, we videotape them. And we show them the videotape, and we say, you know, you look angry here, and angry is bad. And we need to work on that. So I would encourage you, you know, really, really sit with your clients and make sure their demeanor is not, doesn't sort of play into the narrative that the complaining witness is trying to present at the hearing.
Real quickly, because again we are running out of time. What you're going to be in the campus disciplinary process is what's known as an advisor. You're not the student's lawyer as far as the school is concerned. You're there because of federal legislation that says that either party to these proceedings is entitled to an advisor of their choice, including a lawyer, but the school can dictate exactly what role that advisor plays. Almost every school takes the position that an advisor is there to accompany the student to investigatory interviews, to be there for hearings. You're to be seen and not heard. And for the most part, what you're going to be doing in these proceedings is doing a lot of prep work outside of the room to get your client ready for these things, so you don't have to do too much in the room and risk being thrown out because you're not following the rules. And what you're really there for is your judgment. And what I find my role to be is I'm going to possibly take my client out into the hallway to say this isn't going well, or remember this, or they'll let you do that sort of thing, but you can't be doing too much of the coaching in the room, or it's not going to go well. And you want your client to look like he can stand on his own feet anyway.
Right. Should your client withdraw pending the investigation? Probably not, but maybe. So it used to be, back in the day before the April 4th, 2011 Dear Colleague letter, that if you just left, the school would forget all about it, everything would be fine, and the case would be done. Those days, I think, are largely over. The schools, most schools, almost every school is going to go forward with the investigation, going to go forward with the hearing process, whether you're there at the school or not. The one place where it might make sense is when you're thinking about whether you'll have to disclose it later. You know, the student can withdraw, can transfer to another school while the proceeding is still pending at the first school. And if they can kind of get in and the next school, in the way they structure the application, doesn't ask, and they've got the transcript that they need before the finding comes out, depending on what's noted on the transcript during the pendency of the action, then it may make sense to go forward and do it. Although you still got to fight the hearing, because if they ever want to go to grad school, God forbid, they ever want to go to law school, they're going to have to disclose that on virtually every application. There are a couple of graduate math programs we've found that don't ask, which I find fascinating. But it's a hard question. You really got to look at it, and it really, really depends on what your client's future goals and ambitions are. But it's not quite the balm that it was years ago.
And very similarly, negotiating with the school, the only thing I would say is there are times where we have been able to negotiate what it is that will be released if there are questions about a student's disciplinary record, what will be released to another school, and that's always what we potentially it may go to if a student doesn't want to litigate, doesn't have the leverage to litigate, but is there something we can do to neutralize a bad finding, or make it some sort of plain vanilla disclosure that may make it easier for the student to be able to transfer. Based on what we've just said, I don't think we need to go over too much. There's a lot of similarities between how you would go about preparing for a criminal proceeding as well as for a student disciplinary matter, the usual getting the facts, doing your investigation, determining the charges. That's all very similar. The differences are obviously the preponderance of the evidence standard. The prosecution will go forward on much less than in a criminal case. Different definitions that may apply that wouldn't be a criminal matter but are student disciplinary violations. And I think the most sort of the biggest limit to what you can do in the student disciplinary setting is it's very hard to plea bargain or work out some sort of negotiation. The schools are very, very pressed from all sides here, and while your client may have a perfectly good reason for the school to do what your client's asking the school to do, the accuser on the other side probably has an equally compelling story to tell. So you're really stuck between a rock and a hard place oftentimes in these proceedings.
Right, litigation, suing. Okay, so one, due process claims, if you're at a private school, these get substantially harder. If you're at a public school, I think Matthews v. Eldridge is your friend. You have a right to minimal due process if the school has taken away your education, your liberty. Those are at least notice of charges, opportunity to be heard. I think a lot of these single investigator models are subject to challenge, are sort of ripe for challenge. A lot of the evidentiary issues can give rise to a viable due process claim. We've won on those on evidentiary questions violating due process relatively recently. Look at it. Title IX. There are a couple of different claims you can bring there and a couple of different boxes you can put them in. Selective enforcement is certainly one. If there are disparate resources or disparate treatment given to complaining witnesses versus respondents, I think that's a big issue that should get litigated and explored. And with all of this, I'd look at the campus climate. Is the school under investigation from OCR already? Is there activism on campus that would cause them to want to treat these cases differently than they might otherwise want to treat them? Breach of contract is, I think, still probably the single biggest. It's the go-to cause of action. Many states, many jurisdictions hold that a code of student conduct is a contract between the school and the students, and most codes of student conduct say you get a fair shake in a disciplinary hearing, and if you don't, if they don't give you a fair shake, then they breach the contract. That's kind of the basis of the claim, and if they breach the contract in some other more specific way, so much the better. And finally, preliminary injunctions. As everybody knows, civil litigation takes forever to wind its way through the court system. If you're thinking about bringing a lawsuit, your client wants to get back into school yesterday, and the only way that's going to happen is with a preliminary injunction. The case law on this, on whether you suffer irreparable harm for being delayed in your education or being kicked out, is evolving, but there are some pretty good cases out there. And if you're in this place, I'd highly recommend you look at some of the very recent school cases, because there's getting to be ever better language in those.
The only thing I would add on preliminary injunctions is oftentimes if your client got kicked off of campus right away based on, not even after the disciplinary process, but based on the charges, those are often cases where it's going to be ripe for running into court right away or threatening to do that. We've had that where we've threatened and the general counsel clearly got involved and backed off got the Title IX people to back off and got our student back into classes, back into finishing the semester, and guess what? On appeal, he was found not responsible. So it was the right thing for the school to do. But you should always be thinking about that at any stage where your client needs relief.
Have you seen, I know some folks will talk about filing suit to get a preliminary injunction to make the school's hearing be what they think the hearing should be right before the hearing. Have you guys done any of that?
We did one of those and it was to get some accommodations for our client who had learning disability issues, and they weren't giving him what we thought would be appropriate accommodations, and also allowing our toxicologist in to testify. We ended up going to a hearing, and we resolved it before the judge ruled. The school agreed after the hearing to let the things that we were asking for to go forward as part of the process.
Nice.
And that client was found not responsible, so it's always worth fighting.
Yeah.
We're really
questions.
We're here, ready for.
I understand there are 5.
A moment. Okay, so we have, I think, 5 questions from our audience. The first one, are the presenters or participants aware of any successful suppression in a criminal case of admissions obtained from a defendant by university/college investigators or officials? They go on to say student perpetrators are often told that if they don't cooperate in an investigation, they face disciplinary consequences or expulsion.
I'm not. Are you?
No, I'm not.
I
I'm not
haven't
aware
seen
of
it.
that. And it's always, we always say you got to assume this is going to come in. I certainly think that could be a good argument, and some judges might go along with it, but for the most part, I think most judges would say, hey, it's going to come in because you gave it in this setting. And
yeah, and I guess you can see the argument if it's a public school, it's sort of akin to a Kalkines-Garrity issue with a federal employee, but yeah, I can see what the argument would be. We've never had a criminal case where we weren't able to get the criminal case killed, like a parallel criminal case.
Right.
Okay, so the next question, please elaborate on suing a school for doing a poor investigation. In our case, Eastern Washington University, we were denied access to student witnesses and the school refused to interview them. The school denied the existence of security video even though cameras were plainly visible.
Sure. So, I think there are a couple of issues there. I went 10 rounds with one school about whether we were going to be able to interview witnesses. There was a no contact order in place. We really wanted to talk to the complaining witness's friends. But the no contact order said we couldn't talk to our client nor any of his or her, his agents, including me, could talk to the complaining witness's friends. There was that was one where there was a live criminal case, and I went to the general counsel and said, "You're telling me I can't represent my client adequately in a criminal case? That's insane." And he said, "Yeah, that's our position. Go for it." We wound up not filing suit in that one because things worked out, but I can see that argument. I think the standards of care are tricky for investigations, but yeah.
I think it's very state specific, and the Brandeis case is a good example. That's obviously under Massachusetts state law, and New Jersey has this as well, and I'm sure there are other states. There's under every breach of contract, there's also a separate cause of action for basic fairness or fundamental fairness. Pennsylvania does not have that, but I know other states do. And so the first thing is always to look to see, did you follow your procedures? Does your handbook say something about fair and equitable? Title IX, the Dear Colleague letter also says fair and equitable. Try to use that as the underpinning for saying this investigation, not only was it poor, it wasn't fair and it wasn't equitable. And you can possibly use that to ratchet up a cause of action. The other thing could be that if you've got disparate treatment between how the female complainant and the opportunity she had to present her witnesses and your client who's a male did not have those same opportunities, you might have a viable Title IX claim or threat of claim. And so those are the sort of basic things that I would look for to see if I could leverage that into some litigation.
Although you're going to be in a much stronger position if you can show prejudice.
Sure.
I think regardless.
Sure.
So we have a couple questions on this. The audience wants to know how to handle cases where there's a live criminal case from the very beginning, and particularly how to handle input from your client when that's the circumstance you're faced with.
I'll go first on that because I am not. I do white collar criminal defense, but I don't do the. I always get criminal defense counsel. If I get the first call and I think there's going to be or there is already an active criminal investigation, or sometimes I'll get called by the criminal defense attorneys. First of all, I let the criminal defense attorney guide who's going to say what, if anything, and how we're going to go forward. And if there's a live criminal investigation, what we usually try to do in coordination is see if we can push along the criminal piece to get it resolved so that our client can start speaking. But if not, I always say to my clients, you know what, it's more important for you to have your liberty than it is to stay at the school where you are. We're going to do everything we can without having you speak, all the things we've talked about earlier today about getting other witnesses in there, evidence from text messages, maybe a written statement, maybe not. But at the end of the day, your criminal counsel is going to be the one, and your criminal issues are the ones that are going to dominate here and going to determine what it is that we do.
Yeah, and I mean it's a hard issue, right? Because your client is going to be immediately concerned with what's happening with the school, and if you say don't talk to anyone, they're going to freak out because they think they're walking into an expulsion, and they might be right. But of course, what Patricia said is right. You would rather be expelled than sent to prison, or most people would. especially if it's expelled or expelled plus sent to prison. It's really hard. I think the criminal defense lawyers have a knee-jerk response. I have a knee-jerk response that my client's not talking to anybody, no way, no day. I think that is the right answer in a lot of cases. I think in this world, it's not necessarily the right answer in every case. It just depends a whole lot on the facts of the situation and how much is already out there, and how much you can nail down, and how much you can mitigate a bad result from a statement in the criminal case if you make one in the campus case.
I think just my own question on that, I think you probably are aware of legislation that was introduced this Congress, and I believe what it does is, does it stay the disciplinary proceeding pending the outcome of the criminal prosecution? In other words, there's an automatic referral to the prosecuting authorities to determine whether to bring charges, and then if the prosecutor decides to go forward, I believe the disciplinary proceedings are automatically stayed. Matt, I think you might be familiar with this.
Yeah, is that
bill
the
a
House
little more than
Republican
I.
bill? I mean, there are sort of two
They're
bits of
pending.
legislation that are pending, and I think both are probably DOA, but,
Right.
Well, maybe
no one should hire me
this
for
Congress,
legislative
but-
expert.
Right.
Yeah, I mean, if Trump wins, who knows?
So what do you think of those bills? Would they alleviate some of the concerns you have when there's the parallel track?
Yeah, so I mean, the House Republican bill is the one I think you're talking about. That one is weird, and I haven't looked at it for a while. But my memory is, correct me if I'm wrong on this, Patricia, but that what it does is it triggers an automatic referral, and then there's an automatic stay away. But the stay away is kind of all a school can do. The idea being that mitigates the Title IX problem that a woman's sort of confronted with her attacker while she's learning. But I think it really guts the school disciplinary process that we know of now.
I'm not familiar
Yeah,
enough with the nuances to comment on it, but I agree that it's DOA, whatever its nuances are.
Next question. Some schools do not allow expert witnesses, specifically Ohio State. Also, they won't let polygraph examiner reports into evidence, I guess. So what do you suggest?
Sure. So I guess, Patricia?
This is my fallback for everything. Make a record. So, write to the general counsel. This is absolutely unfair. My client's being impacted by your procedure. We have this polygraph report. While it's not admissible in a court of law, it absolutely has, valid reasons for being a part of this, or whatever your other expert reports are. And you might, Matt and I were talking about this before we presented, we've been involved in cases where schools have gone outside their own procedures to allow certain things that aren't written in the handbook, but as long as they feel, and every school's different, there's flexibility at some, no flexibility at others, but there are some places where if they feel like they're doing an even Steven, then they might allow something that ordinarily they wouldn't allow. And so I always say, try to get what you want, try to get what you need, and if you can't, you've at least made a record as to why you're being prejudiced.
Okay, and I think this is, Matt, did you?
No, I think that's...
And I think this is the last question. This person had a case where they gave the Title IX investigator a cell phone video that the accuser took showing the accuser groping the accused, and both of them giggling and laughing, clearly in a relationship. We gave it to show that a romantic relationship existed. The Title IX investigator surprisingly immediately instituted a new sexual assault investigation against the accuser, even though we did not ask for one nor want one. Does this happen often? The retaliatory thing, I guess.
Often is hard. It happens.
Yeah, I would say. So in that instance, you said in that instance they launched the investigation again. Rather than showing it as, hey, this was consensual, it turned into anything's possible in this world of like, I can't believe they're doing that. Really. So, but no, I wouldn't say that's common. I would say they would, normally take that into account on the consent issue and not launch another investigation.
It is. I mean, it's funny. Funny's the wrong word. It's odd how, sometimes they just are almost inhumanly serious about this stuff. And I mean, it's like you've got, like Vogons from the Hitchhiker's Guide to the Galaxy sort of administering rules that you just wonder if they've interacted as humans outside of this process. Yeah, and that sounds like a good example of that.
Yeah, I agree. Throw common sense out the window.
Right.
That's